witness can prove a fact by one of two types of evidence: direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact. Circumstantial evidence is indirect proof of a fact. For example, direct evidence that an animal ran in the snow might be the testimony of someone who actually saw the animal run in the snow. On the other hand, the circumstantial evidence that the animal ran in the snow might be the testimony of someone who only saw the animal tracks in the snow. It is not necessary that any fact be proven by direct evidence. You may consider both direct and circumstantial evidence as proof. A party may attack the credibility of a witness by showing that the witness made a statement or behaved in a manner inconsistent with the witness's testimony. You may consider the fact that the witness spoke, acted inconsistently with his testimony in this case, only to determine the weight you will give to that witness's testimony given during the trial. However, if a witness testified under oath, either in this case or in any other case or court proceeding, you may all consider the content of the witness's prior inconsistent statement as evidence in this case. Evidence is of the greater weight if it convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. A greater number of witnesses testifying to a fact on one side, or a greater quantity of evidence introduced on one side, does not necessarily amount to the greater weight of the evidence. You alone are the judges of the evidence, including the credibility of the witnesses. Credibility means believability. A credible witness is a witness whose testimony you believe. In considering the testimony of a witness, you may take into account his or her ability or opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assume each witness has testified truthfully. If you find conflicts in the evidence, reconcile those conflicts, if you can, based upon the assumption that each witness testified truthfully. Do not disregard the testimony of any witness without reasoned, careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In deciding what or whom you believe, you should use your own knowledge, experience, and common sense gained by day-to-day living. In parties' testimony by way of written or videotaped deposition, a deposition is sworn testimony of witness taken before trial. The witness is placed under oath and swears to tell the truth, and the lawyer for each party may ask questions. The court reporter is present and records the questions and answers. A transcript is a sworn testimony of a witness's prior trial or legal proceeding. The very witness testimony uses the same rules you apply to the testimony of other witnesses. You must not consider testimony or exhibits that were not admitted into evidence. Proof by clear and convincing evidence is a higher standard of proof than proof by a greater weight of the evidence. Proof of a claim by clear and convincing evidence means that the facts supporting a claim are highly probable. In criminal law, we require that crimes be proven even higher standard of proof called beyond a reasonable doubt. We do not use a higher standard in civil cases, but the concerns of beyond a reasonable doubt helps us to understand the concept of clear and convincing evidence. Clear and convincing evidence is a higher standard than the greater weight of the evidence, or lower standard than beyond a reasonable doubt. A battery is the intentional, unauthorized touching of a person in a rude, insolent, or angry manner. To recover damages for battery, Justin Malangoni must prove by a greater weight of the evidence that Craig Jackson touched Justin Malangoni, 1, intentionally, 2, in a rude, insolent, or angry manner, 3, without Justin Malangoni's authorization, and 4, without legal justification. It is an issue in this case whether Craig Jackson acted in self-defense or defense of another person. A person is justified in using reasonable force against another person to protect himself from what he reasonably believes to be eminent use of unlawful force. A person is justified in using deadly force and does not have a duty to retreat only if he reasonably believes that deadly force is necessary to prevent serious bodily injury to himself. However, a person may not use force if he is committing a crime, he provokes unlawful action by another person with intent to cause bodily injury to that person, he has willingly entered into combat with another person, or is the initial aggressor, unless he withdraws from the encounter and communicates to the person of his intent to withdraw, and the other person nevertheless continues or threatens to continue unlawful action. Craig Jackson has the burden of proving self-defense by the greater weight of the evidence. If you decide from the greater weight of the evidence that the defendant, Craig Jackson, is liable to the plaintiff, Justin Malangoni, then you must decide the amount of money that you will fairly compensate the plaintiff, Justin Malangoni. In deciding the amount of money you award, you may consider 1, the nature and extent of the injuries and the effect of the injuries on Justin Malangoni's ability to function as a whole person, physical pain and mental suffering Justin Malangoni has experienced, the reasonable value of necessary medical care, treatment, and services plaintiff incurred, the disfigurement and or deformity resulting from the injuries. Is there something left out of that one?
They didn't provide, I don't have a copy of the finals in front of me.
Yeah, you didn't give them a copy?
It's on your table.
It's right there.
We were doing your closing.
Would counsel